I hijack this on the way to you, David? Thank you. I mean, I don't know anything much about the US Constitution, but I just want to address 2 points from a slightly different perspective. Firstly, I see these writings and these legal theories as really the output, the last gasp of a dying empire. It's basically the same position that was put in the United Kingdom in the 1920s and the 1930s. This group of scholars and politicians who just tried to hold back the floodwaters, the inevitable floodwaters of what was happening. And the whole other way of understanding this stream of scholarship is what in the United Kingdom we call the output of Little Englanders. You know, that we are somehow an island, we can somehow hold back all of this dreadful foreign stuff that is coming. But the reality is, there is no country in the world that takes its international obligations more seriously than the United States, that complies with more of its obligations more fully and effectively than the United States. And the idea that somehow the United States is a lawless country that doesn't engage with international rules is a nonsense. It's just not the case. What's happened is a distinction has been drawn by the upper echelons of political society between good international law and bad international law. And the bad international law is that stuff which has sort of meant that we can't interrogate people in certain ways. But the good international law is all the economic stuff and all of the related stuff. And you find that articulated most clearly in a really weird recent judgment of the Supreme Court, an opinion by Chief Justice Roberts in the case of Medellin, where he basically says, we're not going to listen to the International Court of Justice tell us that we've got to give these wretched Mexicans consular rights when they're arrested.
You didn't really say wretched now.
No, okay, I added the word wretched. It's you know.
I think it was the wretched International Court.
But then he adds a footnote, which is incredible. And the footnote basically says, but if this was an award of an ICSID arbitral tribunal dealing with foreign investment protection and bilateral investment treaties, it would be different. Why did he put that in? Well, obviously someone said to him, hang on a second, Chief Justice, we've got all these American investors who've been using ICSID to enforce international arbitral awards. And if your judgment goes too far, the Constitutional Court in Argentina is going to say, oh, you don't have to enforce this ICSID arbitral award from this American investor against the Argentine state. And so he put in a little a footnote which is replete with the greatest hypocrisy, frankly, because in its ratification of the ICSID Convention and of the UN Charter, there's no distinction drawn between judgments of the International Court of Justice and arbitral awards of ICSID. So what it's really about is isolating bad international law, putting it on one side, and I think the challenge for the Obama administration and for future administrations is to persuade the American people that they actually have an interest in a safe, effective and functioning international legal order. That doesn't mean blindly ratifying every convention. I think if the United States wants to or not ratify the International Criminal Court statute, that's a matter for the United States. The US can't be criticized for not ratifying the ICC statute, but what it does mean is that once you've joined on Geneva, the Torture Convention and other instruments, you are bound, you are free to leave, but so long as you are a party, you are bound, and that means people like David Graham and others doing their work, whether in teaching or whether in practice or whether in scholarship, and making sure that the United States leads the world in honoring its obligations as it does in 99.99% of its international commitments.
And anything I would say in response to that question would be redundant at this point. So why don't we open it up for another question?
Other questions?